Yes, thank you everyone for coming to today's Abrams conversation. We're so fortunate to have our guest this afternoon, several renowned legal thinkers and writers, including Harvard Law professor Stephen Sachs and Knight Distinguished Journalist in Residence and longtime New York Times Supreme Court reporter Linda Greenhouse. And they're joining Floyd Abrams to discuss Stanford Law professor Mark Lemley's article, The Imperial Supreme Court, which was published last year in the Harvard Law Review. So I will go ahead and introduce Floyd, who will then introduce our distinguished guests and get the conversation started. During the conversation, please drop any questions into the Q&A and I'll circulate them to our speakers at the end of the discussion today. So Floyd Abrams is senior counsel at Cahill, Gordon, and Reindel, and has taught courses in First Amendment law at Yale Law School, Columbia Law School, and the Columbia Graduate School of Journalism. He's the author of 3 books about the First Amendment, the most recent of which, The Soul of the First Amendment, was published in 2017. Mr. Abrams has argued numerous cases involving the First Amendment in the Supreme Court and lower courts. Among others, he was co-counsel to the New York Times in the Pentagon Papers case, counsel to the Brooklyn Museum in its litigation against New York City Mayor Rudy Giuliani, and counsel to Senator Mitch McConnell in the Citizens United case. His impact on the development of First Amendment jurisprudence is hard to overstate. So without further ado, I'll turn it over to Floyd.
Well, thank you and welcome everybody. We're so glad to have you here today. This is one of a series of discussions that we have about First Amendment related issues. They're sponsored by the Stanton Foundation, to which we're very grateful for funding these efforts. We're especially grateful today to have an extraordinary panel of people to discuss the Supreme Court today, to discuss it primarily, but not exclusively, through the prism of an article written by Professor Mark Lemley, who is with us today. Mark is the William Newcomb Professor of Law at Stanford University Law School, the author of 8 books. He's published 9 of the 100 most cited law review articles in the last 20 years. And for our purposes today, he is especially welcome because he is the author of the article in the Harvard Law Review titled The Imperial Supreme Court, which got our attention and a lot of people's attention as a way of assessing the Supreme Court today. Linda Greenhouse, who I've known for more than a few years. I've been fortunate enough to know her when she was a journalist at the New York Times, where from 1978 to 2000, she was their extraordinarily esteemed Supreme Court correspondent. She won, I was about to say, an Academy Award, but our equivalent of the Academy Award, the Pulitzer Prize for journalism for her work on the Times. She's the president of the American Philosophical Association and a clinical lecturer of law, a Knight Distinguished Journalist in Residence and senior research scholar at Yale Law School. Stephen Sachs is the Anthony Scalia Professor of Law at Harvard Law School, where he teaches civil procedure, constitutional law, conflict of law, and the like. He clerked for Chief Justice John Roberts on the U.S. Supreme Court, the author of many articles, essays, and book chapters, and is the recipient of the Federalist Society Joseph Story Award. So welcome everyone. I wanted to ask Mark Lemley, who is the author of the article in the Harvard Law Review, which brings us together today, an article called The Imperial Supreme Court, to give us a necessarily brief but poignant summary of the article. Mark?
All right, thank you, Floyd, and thank you all for being here. So yeah, the motivation behind this article was a sense that in the last couple of years at the Supreme Court, there is something new and I think very dangerous going on. I think the court is arrogating power to itself across a wide range of fields and disciplines. Now, there are lots of reasons why people might want to criticize individual court opinions, and this is certainly not the first time people have said, oh, the court is taking too large a role or engaged in judicial activism. But I think this is different. And I think it's different because unlike previous political fights around the court in our history, the court isn't choosing sides between Congress or the executive branch, or courts versus the elective branches, or the federal government versus the states, or government versus individual rights. We've seen disputes in which the court sides to one side or the other among all of those branches. What I think is happening that's new and different is that the court seems willing in the last couple of years to take away power from all of those institutions and centralize that power in itself to do essentially whatever it wants. Some of the cases that do this are cases that are going to be familiar to you. Dobbs in the abortion case, right, takes away individual rights. But I think some of the cases are ones that might otherwise fly under the radar screen. So let me just mention a couple of those. In West Virginia versus EPA, the court applied a newly created, quote, major questions doctrine to ignore a pretty explicit delegation by Congress to the EPA to control environmental emissions and essentially make it impossible for the agency to delegate power, for the court to Congress to delegate power to the agency to fight climate change. We've seen other limitations on administrative agencies, particularly the rather remarkable ruling that OSHA doesn't have the power to regulate workplace health by restricting anything that might also affect health outside the workplace too. Now, there's been a longstanding fight over the administrative state, and you might say, okay, that's nothing new. Perhaps more surprising, though, is that the court is also imposing rather remarkable restrictions on the power of Congress to do what it wants. And the case here that I want to highlight is TransUnion versus Ramirez, where the court held that Congress cannot create a new cause of action for monetary relief unless it uses a theory of harm analogous to one that existed at the founding of the country. The congressional statute here involved deliberate mishandling of credit data, and the court said you have no power to create a cause of action for statutory damages for someone whose data has been deliberately mishandled, because that's not the sort of thing that Congress would have created causes of action for in 1791. Also, perhaps more surprising and a little bit more under the radar screen, we've seen the Supreme Court in a variety of ways take power away from the lower federal courts. So this is not an effort of taking power away from the elective offices and concentrating it in courts. Indeed, the lower federal courts, the court has held in recent years traditional rules of equity to disgorgement in trademark law. You may not be able to apply equitable defenses at all in cases where there's a statute. And the court itself has sort of thrown aside longstanding principles of equity, indeed ones that it has itself articulated. So in the NFIB versus OSHA case, in the course of granting a stay to shut down the vaccine mandate of the Biden administration, the court said that in deciding whether or not to grant a stay, it was, quote, not our job to weigh the equities, close quote, and hardships in deciding whether or not the stay would in fact kill people. I submit that it not only was their job, but in the context of traditional equity and a stay, it's their only job. So there are more cases we can talk about, but I think one thing that's worth noting is the willingness of the court to make substantive decisions on the shadow docket, as Steve Vladeck calls it, without briefing or argument, to convert petitions for stays into substantive rulings and address them on the merits, even without full briefing or argument, and and in certain cases, notably Kennedy versus Bremerton, to sort of make up its own facts to achieve the result it wants. So I don't think this is about favoring one political entity over another. You see cases going in all directions. It's pretty clearly not about one judicial philosophy over another. The court sometimes uses originalism and sometimes discards it. It sometimes uses textualism and sometimes discards it. It sometimes uses stare decisis and sometimes discards it. It's harder for me to know exactly what is going on, why they are doing this. Maybe it's an intentional effort to centralize power in the court, although I'm a little skeptical of that claim. But I think a more plausible explanation might be that we now have a bulletproof conservative majority that's very excited about doing what it wants to reshape society, and it's not going to let the norms, the traditions, or the rules of the law and the history of the court get in its way. And I think that's a problem.
How important are the, I don't want to minimize it by calling them procedural, but are the sort of factors that you've cited as opposed to the court leaning very hard, I don't think you disagree, in a very conservative direction in articulating its decisions. How different is this than the New Deal court rewrite? Well, let's say the old court before the New Deal in the 1930s. You know, striking down minimum wage laws, striking down laws trying to protect people who work in coal mines and things like that. How different is it really in terms of import, at least to the public, than that or the Warren Court? You know, itself very controversial, but certainly leaning in one philosophical direction. I don't mean political necessarily. I mean, how would you assess the importance of the factors that you are identifying?
Yeah, so it's a great question, and I think there is definitely some of that going on, right? The conservative majority in the court has a particular set of preferences, right? We think religion should be treated specially, right? We think guns should be treated specially. We don't believe in abortion rights, and they are implementing those preferences in some of the higher profile cases. But I guess I want to suggest that there's more than that going on, and that we ought to be paying more attention to the cases that aren't so high profile, right? The changes around the procedure for how I take an appeal, for whether I grant a stay, the limitations on the ability of courts to do equity, the limitations on the power of Congress to pass new laws. I think the court. There's Alexander Bickel once called the judiciary the least dangerous branch, whether or not that's true, right? The idea behind it was the court doesn't have an army, but also that the court is subject to a bunch of norms, limitations, and rules that mean it's only deciding cases before it. It's subject to the record. It's subject to the fact finding of the trial courts. And so it's not just got carte blanche to reach out and remake society. And what I worry most about, I think, is that the court is dismantling a lot of those norms. Right? When you dismantle the norm of deference to lower court fact finding, when you ignore deference to agency expertise, right? When you ignore the sort of power of Congress to enact things, when you ignore these court procedures to achieve the goals you want in the cases before you, I think you're doing substantial damage to the long-term legitimacy of the court. Because you're taking away the very things that make it a special and case-driven, rule-driven body, and you make it just more obviously a kind of naked political part of the landscape.
Linda, what's your reaction to what Mark has said, and more broadly, your take on the direction of the Supreme Court?
Yeah, let me just say a couple of things. One, I'm very happy to have been invited to participate in this conversation. My initial reaction to Mark's article was one of jealousy that I didn't come up with this, because I follow the court pretty closely, and he has managed to stitch together within his theme these various developments in a way that I found very compelling and very significant. And Floyd, in answer to your question about, how different is this from the pre-New Deal court and so on. So everybody knew if the court was striking down a minimum wage law. That was obvious. Everyone knows that the court is overturning Roe against Wade. What people don't know are the background principles that are being both discarded and newly invented in cases that don't necessarily rise to that level, but are going to be extremely important going forward. So maybe I'll just take a minute to maybe amplify a couple of the points that Mark made. One, which is very obvious, the fact that the majority in the Bremerton case, the praying coach case, that allowed a part-time public high school football coach to commandeer the 50-yard line for his personal prayer. The Gorsuch majority simply lied about the record. The record said one thing, which is basically that this coach had created a circus, people running down from the stands to join in the prayers, knocking over the members of the student band and so on. The dissent has photographs that indicate this. You read the majority opinion and, just a little quiet prayer. What's the problem with it? Okay, that's an easy one. But going to the West Virginia against EPA case. So as Mark says in the article, the court invokes this made up, brand new method of interpretation in the statutory realm, the major questions doctrine. Now, as the Gorsuch concurrence to Chief Justice Roberts' majority opinion in that case takes great pains to try to persuade us that there's nothing new about the major questions doctrine. That's not true. There's something super new about it. It's the anti-Chevron. We won't go into that, but it's they don't have to get around to overturning Chevron. They have this now principle of non-deference. So the question is, how do you know what's a major question? The court says in that case, if there's a major question and Congress's delegation to the administrative agency has not been explicit and exact, it's a major question, and we decide, okay, how do we decide what's a major question? So buried in that Gorsuch concurrence, he obviously thought the Chief Justice didn't go far enough. He says, well, a major question would be something that's politically controversial. Okay, so get somebody to go on Fox and talk about how controversial it is, and all of a sudden you've got a major question. The other case I'll highlight that Mark mentioned is the TransUnion case about the constitutional ability, it's not a statutory case, the constitutional ability of Congress to confer standing within a statute for a claim that Congress wants individual Americans to be able to go into federal court and assert. This is sort of the end game of a trend that's been going on for a long time. So until the 1980s, the court regarded itself as quite free to imply an individual cause of action from a statute. A statute grants a right. Who has the right to go into court to assert that right? And the court was very generous in saying, well, even if Congress didn't say it exactly, actually, you do have that right. That fell away. There's no such thing anymore as implying a private cause of action. And the court said, Congress has to specify if it wants people to be able to sue. Now we learn that even if Congress specifies it, that's beyond Congress's power and beyond the jurisdiction of the federal courts to honor. And so you can't grant a private right of action even explicitly. I'll stop there, but I'll just say it's a very, very rich article. And one thing that I greatly appreciated about were all the footnotes, because what Mark does is pull together the scholarship in the various silos that he addresses of many very serious scholars. And I'm going to save this article and use those footnotes and keep on educating myself. Thank you.
Thank you for the footnotes is not something law professors hear very often.
But Linda, if I may ask you the same question, or the same sort of question that I asked Mark. I mean, how, I don't know, on some sort of scale, how different is this in your view from the courts which at least have been characterized sometimes fairly, sometimes not, as a very, very conservative court before the New Deal justices got on, or a very liberal court in the Warren court? I mean, are we seeing a change in the manner, in the very nature of what the Supreme Court is doing, or simply what side they happen to be on?
I agree with Mark that there's something different here. It's not given to easy or precise explanation, but what we're seeing in these cases is not simply an agenda-driven desired outcome, A versus B, and A wins this case because that advances the agenda of the supermajority. But we're seeing a change in the way law is done. And the major questions doctrine has great implications, not just for climate change, or for vaccines, or for it's everything. And the refusal to recognize that Congress has the right to create a private cause of action when it passes a statute, that covers many different areas of congressional interest. And so that's where the rubber meets the road in this article. And we've got very smart people in the supermajority right now. They know what they're doing, and they are planning for the future, when a long future, I think, when they may no longer be in charge. But these rules of how the court is to go about deciding cases is what they're building into the very structure, and that's what's going to last and outlast them.
Steve, what do you think? These guys right?
Well, thank you very much for having me on the panel. It's a great honor to participate, especially after having written a high school paper on the Pentagon Papers case. It's great to meet even virtually. I have to say I don't agree with very much that I've heard. I think there is something different about this court, and I think what's different about this court is that it is doing law in a way that lots of prior courts have not. One important test that you should use when encountering some phenomenon that seems totally inexplicable from the other side is what the economist Brian Kaplan called the ideological Turing test. Can we describe the roots of these decisions in a way that those who would author or agree with, or even sort of disagree mildly with the decisions, can recognize as their own? Can we explain what the thought process is of someone who would think that these decisions, any of them, might be the right idea? And I have to say, with respect to Professor Lemley, I find the article sort of a mile wide and an inch thick. I don't think that it does very much to explain to the folks who might not understand the roots of the decisions what the roots really are. If you think of a case like Dobbs, which in some sense is restricting what was thought to be an individual right, but in other ways is conforming to other constitutional commands as the court understands them. It's not what you would think if you're looking at an Imperial Supreme Court, a decision that says this thing that the court had used to strike down a great number of state laws in the past now is up to state legislatures and to Congress. That's not what an Imperial Supreme Court does. A court that says that our own decisions are not gospel, that they are not the Constitution itself, that they can be overturned if they're demonstrably erroneous. That's not what an Imperial Supreme Court does. Likewise, I think a number of the other decisions have explanations that don't require postulating an Imperial Supreme Court. The court is not in the business of saying, we're going to give more power to Congress today, we're going to give more power to the president today. Sometimes it just has to follow lots of little rules in the Constitution that point in various directions, not necessarily all the same way. So, for instance, in a question about the independent state legislature doctrine, one of the examples that Professor Lemley raises in the piece, the claim that that the court is interfering with state governments. It certainly is, depending on how it rules in Moore v. Harper. It might be saying that state legislatures get to do certain things and other aspects of state governments don't. But part of that is because the Constitution uses the words legislature, and it has to figure out some way to give meaning to that, as opposed to other clauses where the Constitution refers to the state generally and doesn't make any distinction among the many branches that it might have. If we think about some of the other examples that are provided, so the major questions doctrine, I should say, I'm not sure that it's correct, but the idea that Congress doesn't put elephants in mouse holes, as it said, is a very old principle. And the idea that the text has to be read in terms of context, and so a certain kind of regulation might be so beyond the vision of the adopting Congress that it's sort of outside the scope of the power conferred. You know, again, I may or may not agree, but it's certainly not a crazy ruling. It's certainly not so unlike many other rulings that we've seen in the past. A case like TransUnion, you know, is a question of Article 3 standing, of when can Congress allow federal courts to decide certain kinds of issues. I think it may very well be wrongly decided, but on the other hand, it's certainly not a surprise if one understands why the courts have been trying to police Article 3 standing in the past, and in particular, as a way of reducing the power of the judiciary and enhancing the power of the executive to be the one enforcing the laws. I think, honestly, in a case like Kennedy v. Bremerton, what's going on here really is a failure to inform one's viewers or readers of the thinking behind the other side. This is a case involving prayer by a football coach at the 50-yard line. And the dispute between the majority and the dissent was not about the facts. It was not about what occurred. It was about which parts of what occurred were relevant to the underlying decision. The coach had previously engaged in much more well-attended prayers, much more potentially disruptive prayers, was told to knock it off, later engaged in a quiet, silent prayer, and then was fired. And then the question is, should the firing be judged in light of the silence of the second prayer or the sort of disruption of the first? That's a decision that the majority and the dissent can go either way on, but without either of them hiding facts from the public. They just disagreed about which facts were relevant. And I think if we're trying to understand, especially in a polarized political time, what another coalition might be doing, what other people think about the law, we have to try and understand it from their perspective. I don't think there's any replacement for that. And I think, unfortunately, that may be one failure in any attempt to describe what the Supreme Court is doing now as imperial. Really, to my mind, it's much more a distinction between formalism and functionalism, of following rules that don't necessarily lead to one particular allegation of powers, but rather might require lots of different choices as you go clause by clause, rather than any sustained effort to put the Supreme Court at the center of all decision-making.
I want to come to Linda. I just want to say for the audience, any non-lawyers, that the Kennedy case involved a high school football coach who, when games were over, went to the 50-yard line and had a prayer, a very public prayer on the 50-yard line. One of the issues in the case was there an obvious sort of pressure on the players to come join him? And there were other issues as well, but I just wanted you to know what it was about. Yeah, Linda, please.
Yeah, I just want to say, I mean, I certainly agree with Professor Sachs that we need to look at the broader context in which these cases are coming down. And let's look at that context. So let's look at the fact that for 200 plus years, this independent state legislature doctrine had not been invoked. In fact, the case that in which it first surfaces in the Rehnquist separate opinion in Bush against Gore, cited this case called Blacker against McPherson that had not been cited by the Supreme Court for half a century. So why all of a sudden? And the major questions doctrine, which supplants the Chevron doctrine, which was a rule of deference to administer the expertise of administrative agencies, why now? And Dobbs, after 50 years of recognition of an individual right to terminate a pregnancy, why now? There's only one reason. It's power in service of an agenda. And Do I try to understand the other side? Yeah, that's how I understand it. Sorry.
Can I say a couple things?
Yes, this was your article which brought us here today, and I will give you extended time to comment, please.
I will try not to take extended time, but I do want to say a couple of things. I mean, I do appreciate Stephen's point that sort of look for sort of what is the motivation, and look, there is no question in my mind, right, that the conservative justices are doing what they are doing in these cases because they think they are doing the right thing. Right. But I fear that they think they are doing the right thing, not in the sense that Stephen describes. That is, I'm just following the rules wherever they lead, whether I like the result or not. I think they are doing what they believe to be the right thing in terms of reaching a substantive outcome, even if that substantive outcome is inconsistent with their precedent, with what the statute says, or with what the Constitution says. So I don't think this is, you can just say this is formalism and applying the rules, and the rules are complicated because they're changing the rules. And here's why I think the changes around the shadow docket, the changes around the sort of rules of equity, the rules of stays are so important, right? Because these are long-standing rules that have been around that the court is simply disregarding. And so one of the cases that doesn't make it into the paper because it's from this term, but that is quite interesting as an evocation of that, is the Title 42 case. So this is the rule that basically said during the pandemic, we're going to keep everybody out at the border. Asylum seekers don't get to come into the country because they might have COVID. We're going to lock them out. The Biden administration sort of decides to change that rule. There's a lawsuit filed by Republican-led state attorneys general. The dispute in the court below is, do the Republican state attorneys general have standing to bring a claim to challenge this, even though immigration is generally a federal policy? That's the dispute that goes to the Supreme Court. The Supreme Court says, okay, we will take that question. Is there standing for the states? But in the course of doing so, we will stay the application of the federal rule entirely on the merits, even though that's not even the issue being presented. They withdrew the case March 1st from oral argument. It looks like they may ultimately dismiss it as moot, but they still haven't withdrawn the stay of the substance of the law, which is not even at issue before the court. That's a remarkable thing to do. That's not simply following the norms and the precedent. That's an effort to sort of achieve the result you want. And I do want to say one thing, because we didn't talk about it, or I didn't talk about it earlier, about the independent state legislature idea. Again, this term, so it's only predictive. We don't know what's going to happen. I'm somewhat hopeful that there are not a majority of justices willing to do this. But I don't think it's right to say, as Stephen says, well, it says legislature in the Constitution, so you got to do it this way. It's not just the case, as Linda points out, right, that we've not followed that for a long period of time. If you think about the implications of taking seriously that form of textualism, they're pretty dramatic. So I'll tell you what else the Constitution says. It says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or the freedom of speech. Right? You could read that textually and say, well, administrative agencies have carte blanche to restrict speech. States have carte blanche to restrict speech. We have not read it that way, and I think we've not read it that way for good reason. Now, maybe this is the thin end of a wedge, and we're going to take back most of the First Amendment, that we're going to take back Marbury versus Madison, and whenever it says Congress is going to do something, the court has no power to do it one way or the other. That would be, I think, a principled, consistent reading. I don't think it would be a good reading, but it would be a principled, consistent reading. But I would be extraordinarily surprised if the court were to say, all right, states now have carte blanche to restrict the free exercise of religion. And in fact, this court has sent every message to the contrary in the last 2 years.
Steve, I think now that we know where everyone stands, what do you have to say? You ready to plead guilty?
No. So I definitely appreciate the sentiment. I think that there are 2 points that need to be made. One is that there is a law that governs the Supreme Court, which is much more powerful than the law of the Constitution. And that's Sturgeon's law, which is that 90% of everything is crap. Every court is going to make a lot of mistakes. And if it's a conservative court, they're going to make conservative mistakes. And if it's a liberal court, they're going to make liberal mistakes. And I'm not here to tell you that every decision that the court has decided on the stay factors properly applied, the preliminary injunction standard and so on and so forth, or the stay factors in Ken, so on. What I am here to say, and this is the second point, is that we have to look at the court comparatively. We have to say, is this court, given that its mistakes, how should we rate it compared to other courts? And on that scale, I just don't see any way to describe this as an Imperial Supreme Court in a way that does not apply tenfold to the Warren Court or indeed to the New Deal Court, which was all the time taking away individual rights such as liberty of contract, taking away powers from the states by upholding various kinds of federal legislation, taking away powers from the president by coming up with Humphrey's executor and drawing that out of a hat. There are lots and lots of different ways in which past courts could be described this way. Indeed, what Linda had said about power in service of an agenda applies no less to Roe than to Dobbs, indeed with much more justification. Why was Roe decided in 1973? Because they had the votes. The constitutional basis for Roe, as John Hart Ely noted, is much more shaky than the constitutional basis for its opposite. And with regard to Mark's points, I do think that it's the case that the independent state legislature doctrine had not come up for a very long time. In part, that's because we didn't have a great many substantive state regulations. We had lots of procedural regulations about whether the governor could veto, bills passed by the state legislature. But we didn't have anything like the independent redistricting commissions and the various other kinds of substantive state regulation of time, place, and manner outside the statutes passed by the legislature of a state. I should say finally that it's very important if one wants to understand the phenomenon to get a sense of what the originalist literature looks like. So for instance, Marbury v. Madison, judicial review may not be in the text of the Constitution, but it was very well understood at the founding. You had judicial review cases like Hilton v. U.S. well before Marbury, judicial review in all the states, or almost all that had written constitutions. The question of whether the First Amendment binds states was widely argued, in the antebellum period. And then under the 14th Amendment, there's lots of theories of why the 14th Amendment might expand the Bill of Rights to the states. So all of this is to say that there's a lot to learn here and a lot that folks can learn from each other across the aisle. So while, my presentation thus far has been rather negative, it really is just a plea for cross-partisan understanding, not to look at things that seem inexplicable and say it must be that the other side is uniquely perfidious, but rather trying to understand what the justifications might be in each case.
Linda, I want to call on you. I also want the audience to know that Linda, her force has to leave early today. So I would like to give you extended time to respond, please.
I don't need extended time, but I can't let that drive-by shooting against Roe go unremarked. Steve, I happen to know a lot about the history of Roe. I've written a couple of books, and Roe actually was not in service of the agenda of the Nixon-Berger court that decided it. The vote was 7-2. Among the 7 were 3 of Nixon's 4 appointees to the court, including the very conservative Chief Justice Warren Burger. And the court actually had no choice about taking up the abortion issue in 1971 when jurisdiction was noted in the case that became Roe, because as you remember your old Fed courts course, I'm sure, it came up under the court's mandatory jurisdiction from a 3-judge federal district court. And in no way were the 7 justices in the majority there looking for, oh, great, now we have an abortion case and we can declare a constitutional right to abortion. The facts are the opposite. The opposite. The country was leading the court at that time. Anyway, I won't belabor that, but I think you've done to Roe exactly what you just told us not to do with what the court is doing, which is to kind of demonize through ascribing to the court an agenda that, in your view, the court doesn't have.
to be clear, my claim is not that the court was going out in search of an abortion case. My claim is rather that Roe's claim to correctness as a matter of constitutional interpretation is certainly no greater than that of Dobbs. And the court certainly did have a choice of how to rule in the case, whether to rule the way it did or to adopt the position of Justice Rehnquist or others in dissent. And it can't be claimed that Dobbs is an exercise of power and not reason without making a substantive argument about, how confident are we that the Constitution provides one way or the other?
Well, I'll just say that I think one way to understand Dobbs is the norm of precedent no longer governs our legal system. We're going to be like, many of the civil law systems that don't recognize the rule of precedent. In Mexico, they have the amparo system, and my neighbor got a favorable judgment on these same facts. Why can't I? Well, because we don't have precedent. And I've read the recent Randy Barnett, Lawrence Solon piece that suggests that a true originalist should give no credit to stare decisis because there's just so many mistakes in 20th century constitutional law, and we've got to just go back to the beginning.
I mean, with respect, I'd say not a single justice has subscribed to that view. Even Justice Thomas, who is the most willing to overturn precedent, has articulated founding era concepts that if a precedent is demonstrably erroneous, if we can be confident that it's wrong, then the court's duty may be to adhere to the Constitution and not the court. But where we're not clear, where it's only a sort of a 51-49 sort of question, then the tie goes to the precedent. Certainly the court has, in many, many cases, reaffirmed precedents that I think everyone would expect a majority of the court, if it were up to them, ab initio, blank slate, would be happy to rule the other way. I don't think it's possible to describe that as not the case, even about the current Supreme Court.
We could call it a version of the major questions doctrine.
Yeah, can I ask you all, but particularly Linda first, because you will be leaving earlier. Give us your general assessment of the performance of this court. I mean, we've talked about it in terms of some particular cases, which are very broad in their impact. But I mean, if you were doing the article not about the Imperial Court, but about this court, I mean, how would you assess it for our audience, bearing in mind that some of our audience are, I don't know how this could have happened, but not lawyers. Talk to us about the Supreme Court today, in your view.
My general assessment?
Yes.
Well, I think I've given it. I mean, I think power has gone to a group of people who have waited for years, who came up through a system and waited for years to have in their hands the power that they're now deploying. Is that true in every case? No. I mean, a good 30-40% of cases the court decides are unanimous or almost unanimous because the court acts like a court and resolves disputes that don't necessarily rise to public consciousness. But the court has, as people probably know, the almost complete, unlike in the days of Roe when it had to take a bunch of certain cases, power to define its own agenda. And I'll give one example that hasn't come up because it's a current case, so it's not in Mark's article, the 303 creative case. This is a case about religion. The court says it's speech, but you can't disaggregate the religion from the speech. A would-be web designer, a Christian, who says she can't possibly design a wedding website for a same-sex couple because she can't possibly be complicit in the celebration of a same-sex marriage. So she wants the right to put on her webpage, by the way, if you're a same-sex couple, don't bother coming to me, I can't serve you. This is not the baker who wouldn't bake in Masterpiece Cake Shop. He actually was in the baking business and he actually turned away a couple. This woman is not in the business and consequently has had no customers. She comes to the Supreme Court lacking case and controversy, lacking standing, and the court grants her case, hears her case, and will certainly rule in her favor because Justice Kennedy stood in the way of getting the flat out win in Masterpiece Cake Shop back 5 or 6 years ago, and he's gone. And so we'll get she presents herself as the Obergefell victim that Justice Alito and Justice Thomas have been so avidly waiting for so they can make the point that they made in their dissenting opinions in Obergefell. So, an earlier court would have laughed at such a cert petition, would have denied it right out of the box. And instead, we're going to get a major speech religion ruling. And, that's the way I evaluate what's going on right now.
Is it your view that the First Amendment argument in the case is frivolous or ought to be viewed as essentially inconsequential?
The court has tried to thread a needle here. The case presented a free exercise claim and a free speech claim. And the court said, we're only going to decide the free speech claim. But of course, it's speech about religion. And I think that is a distinction that in the context of this case cannot be maintained. And so does somebody have a free-floating free speech right not to be, squelched in their freedom of expression? Of course, it depends on the context, but, probably the tie goes to free speech. But I think that's not the way that's not a fair way to actually look at the facts of this case or the court's avid desire to get its hands on exactly such a case.
Mark, back to you. How do you view the sort of matters we've been talking about in terms of where the court is and your assessment of it?
Yeah, and so let me now sort of confess to what I view as the sort of frustrating part of my own article, which is the "what do we do about it" part. So if you think there isn't a problem with Stephen, then that's good. But I like to finish a law review article by saying that's been about here's a problem by saying and here's the solution. And I confess that I really fell short here because the solutions don't seem ones that are either politically feasible or maybe normatively desirable. It's hard to know what to do that isn't, let's hope that when that the justices on the court have the same openness to hearing the other side that Stephen wants us to have, and that when they look at how what they are doing is perceived in the world, they will understand the value of holding on to some of the norms and precedents and rules. I'm not particularly confident that that's going to happen, but I think that might be the best we can hope for, right? Because the alternatives are either things like remake the court. I think there would be useful ways to remake the court. An 18-year term where each presidential term appoints 2 justices would be a great idea. I think it would be constitutional. There are limits in how you could get there. The transition would be an issue, but I think that would be beneficial. But it's never going to happen in our modern political environment. I think that now that the court is sort of clearly and overtly sort of part of the political process, right? One side or the other is going to view themselves as losing out from any limitation on the court, and so it's not going to happen. And I worry that the damage that the court is doing to its own legitimacy, if it continues, right, is going to rebound negatively in a really significant way, right? And that if the court decides to do something like adopt the independent state legislature doctrine, right, there's going to come a point at which a state or a federal government is simply going to say, no, you know what, our reading of the First Amendment is this controls Congress and not the administrative agency, and so we don't have to do what you say. And I, as someone who's kind of like trained and spent his entire life in support of the rule of law, that makes me really nervous.
Can you imagine as a reality a president who might go along with that? That is to say, simply would not enforce, would not live up to whatever the court says is the law.
I can. I mean, I don't think that would be true of the current president, right? But I certainly think it would have been true in appropriate circumstances of our past president. And I could imagine a Democratic president, right, who was more willing to say, you know what, we're just done. We're not going to pay attention. I don't want that to be the case, but I don't. But I worry that we're kind of moving in that direction.
We came very close to that when the court, Chief Justice Roberts' opinion, said the Trump administration could not ask the citizenship question on the on the census. Trump came within minutes of going on the air and announcing his defiance of that, and only a couple of lawyers in the White House counsel's office pulled him back. It's not hard to imagine. I have to run, unfortunately.
Yes. Thank you so much, Linda.
Can I say one other thing on the just sort of court membership? Thank you, Linda, very much. I do think one of the things that it is worth noting, because we lump folks together, right? I think that Chief Justice Roberts has shown a remarkable difference from the rest of the conservative majority, precisely in his desire and willingness to preserve the legitimacy of the court. And I think he pretty clearly has done some of the things that Stephen is suggesting, right? Deciding cases in ways that he wouldn't personally like to reach the result, right? Because he feels either that the law compels it or because he feels that the sort of institution of the court requires it. I think that's enormously important and valuable. And I think really what's happened in the last 2 years is that he's no longer part of the conservative majority of the court. He's conservative, but they have a majority without him. And that's a lot of what we're seeing.
Stephen, can I come back to you on that, on the role of the Chief Justice, of this Chief Justice?
Sure. So I had clerked for Chief Justice Roberts, but let me add the necessary disclosure that nothing I say is based on non-public information. So I think that the chief decides the way he thinks. I think that when he writes the ACA opinion upholding it under the Affordable Care Act as a tax, I think that that's a very chiefy opinion. I was surprised by it, but it wasn't shocking to me. When I see him deciding less than
stay on that though, Stephen.
I'm sorry.
Please stay on the ACA for a moment. A very chiefy, not cheesy, chiefy opinion. Because what? Because he really believed that
it's very important to him not to decide an issue that one does not have to decide. Now, I should say, despite my immense respect for him, sometimes that can be to a fault. There have been cases where his willingness to push the statutory language as far as it can go, and some would argue that it went even further in an effort to avoid a broader constitutional holding. And some would make the argument in Dobbs that his position is not one that can hold up under scrutiny. I'm thinking of an earlier point that a decision doesn't just have to be narrow; it also has to be right. So those who take issue with his position in Dobbs, trying to uphold a 15-week ban but not overrule Roe and Casey more broadly than that, there may not be enough to support it. Although I'm entirely persuaded that he believed that it was the right way to rule in the case and that it dealt with all the issues that needed to be decided. But of course, what needs to be decided depends on what you think about the merits and whether the intermediate positions can hold the weight. One salutary thing I think of the current majority is that whereas you used to have the Kennedy brief, the lawyers would cite a lot of past Justice Kennedy cases in an effort to get his vote and sort of shape the arguments in that way. And then for a period, you had the Roberts brief, where the chief's vote was really the one that was seen in play. And so people would write. Now you have the Barrett brief, the Gorsuch brief, the Thomas brief, sometimes the Alito brief, sometimes the Kavanaugh brief. And I think at this point, it's really much more of an open game. I don't think that there's a single swing justice anymore. And I think, honestly, that Barrett brief and such kind of arguments are often the better arguments, at least from an originalist perspective. Now, it may not be that they always decide them the right way, that's for certain. But I do think that, the court is not, as Mark had suggested, clearly and overtly pursuing political ends. People may interpret what it's doing that way. I think at the absolute worst, one would have to say it's sotto voce pursuing political ends. But I honestly don't think that that's how they're thinking of it. I think that they think that they're each doing the right thing, as Mark had said, and that many of their decisions, even if one could criticize them from one way or another, are in general responding to the right kinds of factors. I don't think there's anything that the current court has produced that is as much of a howler in terms of argument as Griswold v. Connecticut, which is that's the contraception case that sort of very few people would want to see overturned on either side of the aisle, but that, in general, in 1L con law classes is a little bit hard to market because the court's reasoning is very odd. It sort of doesn't look much like normal lawyerly reasoning. And I think that there's nothing that's come out of the Roberts court at any point in its history that's on a par.
You don't think the Ninth Amendment can be wheeled out?
No, because I think the Ninth Amendment is it's a rule of construction. Madison had wanted something like that in so that the existence of certain rights in the Constitution didn't suggest that no other rights, whether customary or natural or common law, were thought to be important. But it wasn't necessarily providing for a generic, textual limitation on the powers of Congress or on the powers of any other legislature.
Let's come back to the author of the article that brings us here today. We've strayed, and with my encouragement too, because I really, we do have an audience, not all of whom have read your article, and many of whom are not lawyers, but who are very interested in the sort of topics that we're talking about. And I'm interested on a sort of a broad level, Mark. I'm shying away from saying notwithstanding the conclusions that you reach, but taking into account the judgments expressed in your article, how would you compare the legitimacy of this court's activities to those of earlier courts that we look to for at least historical guidance?
So, I do think, as I said earlier, there's something interesting going on here, right? So, Paul Levy in the questions asks, so how is this different than the Warren Court? You've asked both the Warren Court and the pre-New Deal Court. And I think this court shares with those courts, right, an ideological commitment to a particular set of results. I disagree with Stephen that they're just sort of trying to apply originalism faithfully or textualism faithfully or doing whatever they want. If they are, they're doing a remarkably inconsistent job of it. Because sometimes we do textualism and throw originalism out the window. Sometimes we do originalism and throw textualism out the window. Sometimes we look at the dictionary and throw them both out the window. And even when we do originalism, we often throw actual history out the window, as we saw both in Dobbs, but also in the Second Amendment case, in the
New York rifle case.
I'm sorry. Yeah, the New York rifle case.
The
right?
New York rifle case. Yeah.
Yes, right. So I think But as I said, when we started out today, right? I mean, I think if this were all that was going on, that would be a reason to criticize the court, but it maybe wouldn't be quite as new a reason to criticize the court. I do think that the changes in procedure, in how they take the cases, in their willingness to manipulate standing in both directions, right, to take up 303 creative when there's no standing, and to deny that being entitled to be paid $1,000 gives you by a congressional act gives you standing, right? I think those are in fact efforts to move along the substantive ideological agenda that the justices in the majority have. And I think it is the more dangerous thing to do that, right? To decide we're going to reach out and take the cases we want and not the cases we want, not using the principles that we have always used for deciding that, to decide we're going to make a substantive ruling on the merits that affects thousands of people's lives at the point of a stay, without briefing, without consideration of the legal rules. Those are, to me, the more dangerous decisions, because those are not ones that are going to ebb and flow as easily with the whims of the majority justices, right? Those are the ones I think that if we get rid of these norms, they're going to be really hard to get them back.
Kelsey, let me ask you, are you there? Yeah.
Yes.
Have we any questions? I want to make sure we do get to questions from the audience.
Sure. Yeah, we have one question that hasn't been answered. So this person says, two things are true about Roe versus Wade. First, a serious argument can be made that it was wrongly decided. And second, there's been a decades-long political movement to overturn Roe, with which the majority of the members of the current court identify and were appointed by presidents explicitly seeking justices committed to overturning Roe. And the question is, would Dobbs have come out as it did if only one of those things were true? And if so, which one?
Steven, you want to take a first shot?
Sure.
Yeah.
So, what I would say is that I appreciate the question, though I worry that it's confusing two different kinds of explaining judicial decisions. One way of explaining a judicial decision is say, what are the good grounds for this judicial decision in the law? How can we justify it? Or how is it not justified? Another way of explaining a judicial system judicial decision is sort of physically what caused these people to be the people on the court to render the decision. So, you could talk about Casey, for example, as being that's the result of doctrines of stare decisis. Or you could talk about Casey as being the result of Judge Ginsburg or Judge Bork having been denied confirmation because of various reasons, and then Judge Ginsburg having been denied confirmation for various reasons, and then Justice Kennedy coming onto the court. Both of those are explanations. But it's not clear that explanations of the latter kind have anything to do with the legal justification. So the fact that, when was Justice Fortas forced off, and, the Iraq War didn't go very well, and so therefore the Democratic candidate was elected in 2008 instead of the Republican one, those things just happen. They're not something, it's true. If there were not a political coalition capable of electing presidents and senators of a certain mind, you would not see people of that mind on the court, because the court is appointed by presidents and confirmed by senators. But that doesn't mean that the decisions themselves are suspect in any way or are political in any way, just because you don't get on the court unless you pass a gauntlet of politicians. And that's true no matter what you think. All with it, to my mind, a law professor should really say, in terms of, thinking through how, what's the right constitutional answer here, are the legal grounds, not the what's necessary to get a coalition of justices on board.
So I agree with almost all of that in the general terms, although I think Roe is harder, right? And I think Roe is harder, and the questioner is getting at this point because it was explicitly used by both sides as a litmus test, right, for appointing a justice, right? So this is not a case in which, by accident, by happenstance, or by the political will of the underlying presidency, right, we end up with justices with particular views on a legal doctrinal question, right? These are circumstances in which we have for decades been appointing justices in significant part on the basis of how will they rule on Roe. That does strike me as worrisome, right? On the Roe issue in a way that is not true of pretty much any other issue. I mean, I think there are lots of political issues on which people have contested views, right? But people are not being appointed or denied appointment to the Supreme Court on the basis of their views of the Second Amendment, for instance. So, I mean, I understand the question to be, given Casey, given stare decisis, would the court in fact have done something if it were not a court that was engineered in part to try to find people willing to overturn Roe? I don't know the answer to that question, but I think there is a perfectly reasonable answer that even if you think Roe was wrongly decided as a matter of legal doctrine in 1973, right? Not just the principle of stare decisis, but the fact that we have built a legal infrastructure and people's lives around it for 50 years, right, might have prevented a different court from overruling it, just as it did with Casey 3 decades before.
I mean, it might, but it depends on one's view of whether the Casey version of stare decisis is the right one.
I will note the one other thing, which is I do think in a world in which we could have political reform that was not inflected with ideology, and I fully understand we are not in that world, right? I do think that some things like the accident of how long do people stay on the court end up tipping things in ways that are worrisome, and I'd rather see a court that was kind of more that was designed to sort of reflect the will of individual presidents and justices in a more equally weighted way.
So I would definitely agree that. Oh, sorry. Go ahead.
No, go on, please.
I would definitely agree that the sort of accident of which justices happen to leave the bench when is unfortunate. I think it creates a sort of morbid fascination with the lives of the Supreme Court justices that I would just as soon not have. The problem is that it's hard to get away from in a world where views of the law are highly polarized. So even if you had 18-year terms, there's always the chance that someone's going to be hit by a bus before their 18 years are up, and then they might have to be replaced. And that fact could change the balance of power in the court. The real underlying feature of the court is that we've just got very polarized views of the law, views of the law that are absolutely central to, some folks are, their negation is absolutely central to others. And in any system like that, you're going to have worries about, oh my gosh, what if the other side has 5 votes when we only have 4? To my mind, the only solution to that really is, starts in law school. It's not something that we can do with the changes in the court. I note that Yale, where Linda teaches, has 0 conservative public law scholars. Stanford, Mark, where you teach, has 1, Mike McConnell, conservative public law scholar. I'm lucky to teach at Harvard, a place that has a number of them. But I feel that if students are not exposed to different ways of thinking about the law early and to understand the kinds of considerations that are at stake, it's going to be hard to avoid the sorts of polarization that we've seen. And it doesn't mean that somebody has to be a conservative to teach the way that conservative justices think well. You certainly, can teach outside your comfort zone. Anybody can. But it helps to have that sort of discussion within a faculty and within a law school. And I think that we're just not serving our students very well if we don't prime them to understand how the other side thinks relatively early on.
Any other questions?
I don't think we have any other questions from the audience. I'm happy to ask another question if we want to continue, or we can end.
No, why don't you do one and I'll do one? Go on.
Okay. I wanted to ask a question about Professor Lemley. You suggest that Congress could sort of fix the Article 3 standing issue in some way by making clear that certain injuries aren't really injuries and others are. Could you say more about that and why you think the court would accept that?
So would the court accept it? That's a hard question, right? I mean, I will note that the standing doctrine itself, as it's currently articulated, is a 20th century creation, right? An originalist court, right, would not actually view this version of Article 3, right? And really, it traces in its modern form to the early 1980s. There is there's Supreme Court precedent that says Congress can sort of kind of change these things, right? Lujan versus Defenders of Wildlife says the injury required by Article 3 may exist solely by virtue of statutes creating legal rights, the invasion of which creates standing. That is, I think, maybe it's completely overruled by TransUnion. It is certainly inconsistent with TransUnion. But I confess that I am by no means an Article 3 expert. I think one thing Congress could clearly do is delegate these causes of action to administrative agencies. Right? If you take seriously TransUnion versus Ramirez, and there is no Article 3 standing to award statutory damages to people whose data has been stolen, then I think there is no limit on the ability of Congress to say administrative agencies can award $1,000 in statutory damages, right? And in fact, I take it that administrative agency wouldn't even be reviewable. Decision by that administrative agency wouldn't even be reviewable by an appellate court because there would be no Article 3 standing over the dispute between the parties. Now, I suspect when it came to it that the court would say nothing of the sort. I suspect that it would say, no, we think we have a role, we have an interest here. But I think there are at least potential patterns by which Congress could do this. Some of them involve withdrawing jurisdiction from the federal courts, handing them either to administrative agencies or to state courts.
Let me ask you a final question of you, Mark. I want to come back to Stephen's last or penultimate statement. Do our law schools lack, is there a problem, a problem of a pedagogical problem that there are too few conservative scholars at our great law schools?
I think the answer to that is probably yes. Right. I absolutely agree with Stephen, right, that you want people with different perspectives writing and teaching, and that's a valuable thing. I will say this is not, in my experience on appointments committees and having been on faculties now for close to 30 years, this is not the result of sort of anti-conservative animus. For the most part, we actually sort of affirmatively look for conservatives to come to our faculty, right? Because we understand this to be a problem. That might turn out to be illegal when the Supreme Court decides its affirmative action case later this year. But it is at least something that we have been trying to do. I will note that one of the things that I think makes it more challenging in the post-Trump era, right, is that the sort of political majority that is now sort of associated with the Republican Party is not in what I think anyone could reasonably call conservative by any historical measure. And so the question of whether you hire a conservative or a libertarian is an interesting question, but it might be a different question from, do I hire an authoritarian populist, right, who believes in overthrowing the election results? That's something I think that's much more challenging for a law school that is, I think, and has to be at the end of the day, kind of cemented around the rule of law. I guess there are analogies to sort of like, do we hire sort of Marxists in the 1960s and 1970s to teach that we ought to sort of overthrow the government? But I fear that sort of conservatives outside of a few select intellectual circles seem to be a vanishing breed, and they're not the breed that is in the political ascendancy in the Republican Party.
Well, Steve, I will thank you for your comment, which led to that final exchange, one of the many interesting exchanges today. Thank you to you both. Thank you, Kelsey, And thanks to our viewers.
Thank you all.
Thank you for having us.